Good afternoon. My name is Jim Leonick. I'm a New York personal injury attorney, and I'm going to highlight four different things that over the years I've learned from clients that are misconceptions that a lot of people have that I'd like to shed some light on. So the first is when someone starts a lawsuit over a personal injury matter, they think that they're suing an insurance company, especially if they have a relative or a friend that is involved that has to be made part of that case. Their belief is that the insurance company is the party that they're bringing the case against, and they're not suing their friend or their relative or their neighbor. That's not the case. We don't typically sue insurance companies unless there's a contract dispute over a policy or something like that. When you sue over an accident, you're typically suing an individual, or you're suing an entity, a corporation that owns a piece of property, or an employer, a doctor, someone who is driving a car, and things like that. So that's one misconception. Insurance companies do stand behind those people, and there is insurance available. And to the extent that there's insurance, that insurance may pay if you're entitled to money at some point because of a settlement or an award. Another misconception is that injuries override liability. What do I mean by that? Some people think that because they have very serious injuries, that those injuries allow us to forget about the fact that someone is not at fault for how an accident happened. You have to be able to prove that someone caused an accident, that they're responsible for that accident before you can be compensated for injuries. If you trip over your own feet and it's no one's fault but your own, the fact that you have a broken nose or a concussion is no one's fault, therefore no one has to pay. And sort of the corollary to that is the third thing I'd like to talk about, which is that liability overcomes not having injuries, sort of the opposite. In other words, someone is 100% at fault. There's an automobile accident and the driver of another car was drunk and caused an accident, but yet you walked away with little or no injuries. In a situation like that, it's very difficult to recover. You still need to have injuries. You need both. You need liability and you need damages. And ultimately, you also need someone's ability to pay, either through insurance or themselves. The last item is timing. A lot of people feel that these things take much more time than they should, and that their lawyer perhaps is not moving the case along fast enough. Realize that we are running two different processes at the same time. One is a claims process where we're providing information to an insurance carrier or a risk manager who is evaluating whether this is a matter that they want to make an offer on or settle or go to arbitration. And at the same time, we're running a court process. The court process takes a long time. There's no two ways about it. The courts are overloaded. The courts couldn't possibly try all of the cases that they have. So 90% of cases are settled at some point along the court process. So these are some of the things that are misconceptions that people have about personal injury cases. And I'm happy to discuss these with you, or any personal injury case that you have, whether it's medical malpractice, car accidents, trip and fall accidents, or any type of injury case you have. Thank you.